All right, hello. We should be live at this very moment, and we're right on time. It's right at 5 o'clock. So I put a little hello in the chat just to make sure it's working. I see it there. So that's working. You all can communicate with me through the chat, ask any questions that you have, anything like that. I know it's a holiday weekend, a busy weekend for all of us. So really, we're just going to be live for about an hour or so. We'll first give a quick spiel on what's been going on with Umar Johnson in case you're unaware of who he is and what he has going on. You never know, right? You may not be as involved with some of the online things that are going on. And then I'll preface some of the lawsuits, and then we'll get into two particular lawsuits and what's going on in those cases. So we'll do it that way. So hello, everyone. Welcome back to Empowered Esquire TV. I am your gracious host here, Phylicia Pearson, attorney, educator, and entrepreneur, but most of all, legal nerd who loves sharing information with you and having a discussion with you about these things. So today we're talking about Umar Johnson and the multiple lawsuits against him. For those of you who may be unaware, Umar Johnson is a self-proclaimed school psychologist, therapist, relationship counselor, life coach, and you could also say that he is a social media personality. He seems to be very, very popular, particularly on Instagram and YouTube, with a lot of his pictures and sayings being turned into memes and things like that. And he's also been on The Breakfast Club, I think about 3 or 4 times at this point. So I think it's safe to say that he is definitely a social media personality. Now, I always have to preface this, you guys, it is a holiday weekend. I do live in an urban area. So if you hear an ATV or some random vehicle outside, you know what's happening, right? As I just heard one. Don't know if you could hear that one. Anywho, so Umar Johnson has several lawsuits that have been brought against him, some in the past, some in the current, but I'd like to discuss two of the most current lawsuits, break down those causes of action, and have a practical conversation about whether or not he can defend himself against these lawsuits in an effective manner, what could happen if in fact he's not able to defend himself in these lawsuits, and how to bring a lawsuit as a plaintiff, right? So exactly our tagline, it's going to be some life lessons through a legal lens. So let's jump right into it. I'm going to share my screen so I can show you some of the actual court documents. You'll also learn today how to search for a case, because in case you are unaware, oh, said case twice there, all of these cases, when you file with the court in your district, in your state, wherever, these documents are public, okay? So let's start with, you know what, we'll start with the case that actually recently was closed. That is August Archibald v. Umar Johnson. And there was a lot of back and forth online as to whether or not that case was an actual case. Some people said it didn't seem like authentic court documents. Those people were wrong. August Archibald v. Umar Johnson was an actual lawsuit. You can find it in the Eastern District of Pennsylvania. You can find it on the Pacer website, et cetera, et cetera. So let me show you that. Let's share my screen. Share screen. All right, we're going to do entire screen so you can see everything. Perfect. Okay, now here, let's take a look at, this is a screenshot of Pacer, right? So for those of you who are unfamiliar with Pacer, I'm gonna bring this up and actually make this full screen. Awesome. So for those of you who are unfamiliar with Pacer, here, this is exactly what Pacer is. It is public access to court electronic records. So as I said, any case that is filed, whether it is a state case, some type of local case, or a federal case, is public record and can usually be found online. Now, Pacer is for federal cases, right? So here you see, this is the case search for Johnson, for Archibald v. Johnson, right? So you can see here what I searched for in Pacer. And now you see the results that I got. So you see, I have an Archibald v. Johnson here, case number, Pennsylvania Eastern District Court. I have a date filed and a date closed. Now, there are some other Archibalds here, but I want you to take note that these are Archibald v. Johnson and Johnson, i.e. the Johnson and Johnson company, right? So that's not Umar Johnson, Okay. And you'll also notice that these cases are filed in New Jersey and New York. So this case here, Archibald v. Johnson, you see the case number. This is the case in which a man named August Archibald actually brought suit against Umar Johnson. He filed his case on December 7th, 2020, and the case was subsequently closed on March 29th, 2021. Now, we'll get to why the case was closed and what happened there. But first, let's have a quick combo about the case that he filed, shall he? So we have some more screenshots here. Let's minimize that one. And we'll go, oh, hello to K Business Podcast. Good afternoon. And we will now go to, and Pacer is a federal database. That is correct. There are state and local databases for state and local cases, and we'll get to that in our second case. So here, is that the first page? No, we want to go to the first page of the suit. So I'm going to bring up all of the pages, and we'll start from the top. Here we go. So how do you know when something is a bona fide case document, people? Well, particularly with federal cases, here's how you know. You see at the top here, it says case number, and it has the case number. It says document number. It says the date that it is filed and how many pages were filed. That is one of the first hints for you that this is an actual case. It is a real case. It's not fabricated. Now, some people online made the statement that they didn't see an index number and that made it fake. No. So I have some news for those of you who aren't familiar with the filing of cases. When a plaintiff initially files their complaint, there is no index number, people, because there's no case number as of yet, correct? So your initial summons and complaint usually won't have an index number on it yet. That's totally normal because when the plaintiff began the case, there was no index number to put on their complaint. Make sense? All righty. So here you have it. August Archibald v. Umar Johnson, United States District Court, Eastern District of Pennsylvania. He identifies himself as the plaintiff. He lists all of Umar Johnson's AKAs. He then goes into some procedural information, giving the code for why this court has jurisdiction. There's another practical point. You guys, when you're filing in a case, there are a few things you have to tell the court in your complaint. You have to tell them who you are, who the defendant is, why they have jurisdiction over your case, and why they should hear your case. That's called jurisdiction and venue. So here he's done both, right? He's given them some codes and he stated that they should have original jurisdiction over this kind of case, okay? He then goes into a little bit of what he calls background, which is really just him talking about Umar Johnson, right? Not necessarily relevant to our point. Now, this is the second page of what he filed. He goes into some events and facts stating that Umar Johnson purports to have a doctorate degree in clinical psychology. He goes to suggest that Umar Johnson may not actually have any professional credentials. He then shows pictures of the school, goes into the public record of the purchase of the school, and then discusses the donations that were received. Now, this is where it gets juicy. He alleges that Umar Johnson received donations of an estimated $2.5 million. Now, where he got that number from, we don't know, but we assume that he had some sort of substantiation by which he used to calculate that number, right? We assume. So that's your second page. Now we're going to find our third page. Is that it? That might have been the fourth page. Our third page, here we go. He then goes into the fact that Umar Johnson has not provided any accounting of the money that he received for FDMG, which to my knowledge is correct. He mentions that Umar Johnson has a history of threatening certain people with physical violence. So he does that here in paragraph 9. He then goes on in paragraphs 10, 11, and 12 to start mentioning some people who he believes are in league with Umar Johnson. And you can see here he names those people and he names what he believes they have done to support some of the things that Umar Johnson has done. Now here in number 15, this is an important paragraph, you guys. When you're filing a lawsuit, you have to have something called standing. Standing means you have to have the right to sue the person that you're suing. So something had to have happened to you. You had to have been injured in some way for you to sue that person. And this is it right here. He says in paragraph 15, I, as in August Archibald, previously supported and donated to Johnson's school campaign in good faith with the belief that the FDMG Academy school would be open, operational, and functional by August 21st, 2019. To date, the FDMG Academy has not opened. So remember when we looked at the case docs and we saw that this case was filed December 7th, 2020? So this man is alleging, August Archibald, and I should say alleged because the case is now closed, that he had standing as a donor to FDMG who expected FDMG to open, but it never did. Okay. So he has some pages with some other kind of tenuous information. So although we'll quickly go through page 4, after that, we'll just move on to page 9 and talk about why the case is now closed. So now we're on page 4. He mentions some more things about reporting. He mentions that Umar Johnson has made some comments about African-American people here in paragraph 17. And then he goes on to talk about some of the many statements about repairs that Umar Johnson has made, right? So you have that here in these other paragraphs 20 through 22. And now we're going to go to the second to last page here. Okay, so now here you see he mentions what his legal causes of action are and what his damages sought are. Some more essential things. If you're filing a lawsuit, you have to tell the court why you are bringing this case legally, meaning what's your legal reason for being able to bring this case? So here, August Archibald says he's bringing this case in the cause of action of what's called torts. He states that tort claims against Umar Johnson and all of his alleged aliases in his official capacity and individual capacity for fraudulent misrepresentation, false advertising, negligent misrepresentation, and unjust enrichment. A lot of legal terms there, right? So let's break them down. Fraudulent misrepresentation. Fraudulent misrepresentation is when someone represents something to you that is not exactly true, right? So for example, in this instance, when Umar Johnson says, I am seeking donations to purchase a school, right? August Archibald is saying that a fraudulent misrepresentation occurred because Umar Johnson made those statements, but in fact did not actually use the donations to open a school. So that's the action he's alleging is connected to fraudulent misrepresentation. And fraudulent misrepresentation is when you misrepresent something with the intention of getting money or services or something from the other person, knowing that what you're telling them will actually never occur. That's fraudulent misrepresentation. Now, false advertising. This usually applies to products, right? So you may see someone sue, we'll use Johnson & Johnson since we've heard of them this little go around. You may see someone sue Johnson & Johnson because Johnson & Johnson is selling baby oil that alleges that it keeps you moisturized for 48 hours, right? And then the person says, well, I used the baby oil as directed and I was only moisturized for 2 hours at best. That is false advertising, right? That's an example of that. Negligent misrepresentation goes hand in hand with fraudulent misrepresentation. But you can see that there's a different word there, right? There's fraudulent versus negligent. So here's the difference. A negligent misrepresentation is when I solicit money or services from someone and I represent that something will happen to them that I am not sure if it could or could not happen, right? So I'm not necessarily being fraudulent because I'm not representing to them that it will happen when I know it won't, but I also don't really know for sure that it will, right? It could, it couldn't. That's negligent. And lastly, unjust enrichment. Unjust enrichment is when someone is enriched in some way. They gain something in some way by way of a negative action, right? So if I commit some sort of material breach in a contract, if I commit some sort of fraud and I am then enriched by that, I get money from that, I get services from that, that is called an unjust enrichment. And then he has his damages sought. He says he's seeking monetary damages and injunctive relief. He should have been more specific there, right? He should have how much money he's seeking, and he should have what type of injunctive relief. So, injunctive relief is when you are asking someone to stop doing something. So, I could file an injunction that says, I would like for Johnson and Johnson, we'll use that example, to stop selling this baby oil because they are using a false advertisement, right? The part where I am requesting that they stop selling the baby oil, that's an injunctive relief request. So here he doesn't really list any specifics, which he should have, but that's another point that we'll get to later, right? So that is the complaint that was filed by August Archibald. I'm going to stop for one moment just to take some quick questions. Does anyone have questions about the complaint that we just looked at, filed by August Archibald, before we get into what happened to that complaint? While I give you guys a second, I'm going to say hi to everyone in the chat. I already said hi to K Business, but I'll give him a second shout out because he's awesome. Everyone subscribe to K Business if you're not. He's really awesome. He has a business channel, shares a lot of good business and financial info. Hi to Amare Shager. You guys, that's my sister. She's so gorgeous and wonderful and super intelligent and should have a YouTube channel. Hi to Crime Spotter. What's up? And let's see. I think I've gotten everyone that's in the chat at least. Hi to everyone else watching. I don't see any questions about the complaint. So we're going to get into what happened to the complaint. So let's take a look at docket report. Is that it? No, I'm going to pull up thank goodness I stopped sharing my screen. My Amazon shopping list is popping up. My goodness. What I want to show you all is the list of, where is that? Oh, here it is. Okay, perfect. So we're going to share my screen again. I'm going to show you guys how you can view the list of what has happened in a case that is in Pacer if you don't have Pacer, okay? So let's go share screen. Oh, I see a question. Does the money collected under pretext of being donations? Crime Spotter, I think you mean, did Umar Johnson collect this money under the pretext of them donating? Yes, he did. It is a donation to the creation of the Frederick Douglass Marcus Garvey Academy. And that is a good point, Crime Spotter, because a donation is different than an investment. So that flows right into K Business's question. His question is, can Umar get away with this? So I think what Kay is asking is it okay? Is it legal that he has solicited donations and has not, in fact, created FDMG? Well, that depends, right? So as I was saying, a donation and an investment, they function differently. There is a higher fiduciary duty with investments, but there is still a certain level of duty with donations. Don't think that just because you donate to someone, you've thrown your money in the trash can, right? Legally, if someone is purporting as a 501c3, so for example, Umar Johnson says that FDMG is a 501c3, that is an IRS filing status. If he is soliciting donations through that IRS status, he does have some level of duty. But here is the problem. You need substantiation. So when you're an investor who's investing in a corporation, you get what? Quarterly reports. You get marketing stats. You get all these things that you could use as an argument to say, hey, StreamYard, you're not using my investment correctly, right? But FDMG, because it's not a corporation and because it's not an investment, it's a different situation. So these, I guess you could call them donors, right? Yeah, we'll say donors. These donors aren't getting marketing reports. They aren't getting any type of information, right? And it's not necessarily that they're entitled to it because they're not investors, they're donors. There is a lower level of donor reporting than there is investor reporting. Now, with that being said, if someone was privy to information which they could use to actually directly substantiate that Umar Johnson did not use these funds for FDMG, then yes, absolutely, donors could take him to court and yes, he could legally be held responsible. But because there's less stringent reporting for a corporation, for a 501c3 and a donor than there is a corporation and an investor, you find yourself in a complicated situation because it's a chicken and an egg situation. It's a, how do I get the information to substantiate that this man is not doing with my donation what he says he is? That's going to be an uphill climb for them. I see someone mentioned that FDMG is missing its annual report. I haven't looked into that, but if they are, they could have their 501c3 status taken away. That's usually the penalty for not keeping up with the reporting, is that you get the status taken away. Crime Spotter says, if Umar didn't say the donations are for his personal use, but use them for such, as opposed to what's been stated for, can he be criminally liable? Interesting. Yes, that depends on the state. There are some states that have on their books certain federal crimes that deal with fraud. And also there are federal mail fraud and other things like that. However, again, they need some level of substantiation. So from the criminal perspective, you know, your attorney general's office and your federal prosecutors, your United States attorney's office, they're going to have subpoena power, right? So they actually do have the power to subpoena bank records, to subpoena phone records, to subpoena PayPal, to subpoena GoFundMe, right? And all these other people that Umar Johnson has collected money through, to trace the money and see, well, did he actually keep it in a separate account? What happened to this money? But those entities, they have to decide to create those subpoenas. They have to decide to investigate. And thus far, we don't think that these subpoenas have actually been served, right? But quite frankly, we don't know. Perhaps Umar Johnson is under federal investigation and those subpoenas are happening. And if so, we'll probably hear about it later on. Crime Spotter now says, so one would need to have a forensic audit done, so to speak. Correct. And unless you are some type of government entity, you don't have the power to do that type of audit without authorization from Umar Johnson. So that's why I'm saying, if Attorney General, if USA, if these type of entities step in, they can just subpoena everything and do an audit and trace the money. But an individual citizen who's just a donor, they can't do that, you know? So let's wrap up the conversation about this August Archibald case. Let's find out what happened in this case, right? I'm going to share my screen again, per usual. Let's see here. This should be it. No. I think I'm opening. Oh, there we go. All righty. So when you either don't have Pacer or are uncomfortable with Pacer, because it can be a bit complicated, this is a website that kind of gives you a very brief explanation of what's going on in a federal case, right? So here you have Archibald v. Johnson. The next issue with this website is that it's not as real time, right? Pacer is going to be real time. So notice that Pacer told us that the case is now closed as of March 29th, and Justia doesn't have that, right? So notice that. So be mindful when you're using this website, okay? So here you have plaintiff, defendant, case number, all the rigmarole. It even tells you presiding judge, which might be good to know. It tells you the nature of the suit. So this was filed as a civil rights claim, but also some other claims as well, okay? And you can start from the bottom here and work your way up. You can see everything that happened. You see when the case was initially filed, you see it was filed in forma pauperis, which means August Archibald alleged that he did not have the funds to pay filing fees and asked that they be waived. And it looks like that was granted, right? You see all of the filings that occurred. You see he filed a second amended complaint, right? And then here you see a filing, right? And it says that there was an order in which the plaintiff had an application for leave to proceed in forma pauperis, as I said, and it was granted. So the court granted that. But then you don't really see much else about what happened here. Although we know that in March, the case ended. Well, let me show you what happened there. So this is from Pacer, you guys. This was filed on March 29th, 2021. So you see here in the United States District Court for the Eastern District of Pennsylvania, teaching moment, For those of you who don't know what this section is, this section of the document is called a case caption. It tells you who the parties are, and it tells you the case number, okay? All right, order, and the order states, and now, this 29th day of March 2021, upon review and consideration of plaintiff's letter motion to withdraw, pause. So what does that mean, everyone? That means the plaintiff requested to withdraw this case, you guys. The case was not dismissed upon request of Umar Johnson. The case was dismissed upon the request of August Archibald. Okay. And supplemental letter. The court construes said motion as a notice of dismissal pursuant to Federal Rule of Civil Procedure 41A1AI. Accordingly, the above caption is hereby dismissed without prejudice. There's a difference between with and without prejudice, you guys. And the clerk of court is directed to mark this case closed. So what does this mean? This means that August Archibald filed a letter and a motion to withdraw the case, and the court granted his request, i.e., August Archibald chose to end this case. Now, a number of things could have happened. Maybe Umar Johnson contacted him privately and they settled the matter. A lot of plaintiffs will file a motion to withdraw because the defendant contacted them privately and they handled it privately, right? That could be it. Or perhaps Mr. Archibald just decided to walk away, who knows? But it is possible that Mr. Archibald received some sort of private settlement of some sort, and he decided to walk away and keep it private as to what happened there. All right, so I am going to get back in the chat for a minute and have a conversation with you guys again. Let's see, where are we? So CrimeSpotter mentioned that it's a federal case because money is coming from multiple states. It could be. So remember, cases and charges are not in a vacuum, CrimeSpotter, right? You can have both. So Umar Johnson could, for example, be charged under a New York law and also have a federal case for the same actions because they occurred in multiple states. So you can be charged in state court and be charged in federal court. And usually, if you're a person who has committed something that is considered to be, egregious enough, both types of charges will be brought. You'll be fighting a state case and a federal case at the same time. That can happen. Let's see. Alrighty, I don't see any other questions per se. Some good conversations going on in the chat. So that is the case of August Archibald v. Umar Johnson, everyone. That case was dissolved, but we have to note that it was dissolved by the request of the plaintiff. So there really was never a day in court in which Umar Johnson defended himself against any of these allegations or in which he addressed any of these allegations. So that's very interesting to consider that some of the things that Mr. Archibald brought up in his complaint, such as what is happening to the donations, those questions were never addressed. So now we are going to move on to the second lawsuit. The second lawsuit honestly gives me a bit of a chuckle, and I swear I'm not trying to be insensitive, but I say that because I've seen some videos of the plaintiff in this suit, and he gets very animated when he's discussing what happened between him and Umar Johnson. So enough of my babble. This is Donald Murray, also known as Don by some of the, the people online. He used to be some type of maintenance man at FDMG, and then he wasn't paid for his work, and he filed a lawsuit, right? So now we're going to jump into that. Oh, wait, before we do, though, I see a question by CrimeSpotter that's really, really good. He wants to know, how would you argue a case for him? If you were to defend Umar, what would be your defense? Well, I guess I would say my first question for Umar, if he were my client, would be, does he actually have a separate personal bank account and a separate account for FDMG, which he purports that he does, right? So my defense for Umar Johnson would be very basic and very simple. I would say Umar Johnson is soliciting donations. He makes it very clear when he solicits those donations that he cannot say exactly when these donations would be used for the building of the school. He has said on several occasions that his dates for opening are tentative, that they are ambitious, and he wants to be able to open a school on that date, but that he may not be able to. Donations are not a business contract, and donations are not an investment contract. And if my client solicits donations for a certain use and says that he is using them for that purpose under his 501c3 status, the person alleging otherwise would have to have substantiation. He does not have the burden of proof. The person who is alleging that he's misusing the donations does. There you go, Crime Spotter. That is what I would argue if I was Umar's attorney. Someone says, would you take the case if he reached out to you? That's a question. And if any of you have ever read Johnny Cochran's biography, there are a couple of questions that attorneys should never answer, and that's one of them. So I'm a student of Johnny Cochran. I don't answer those kinds of questions. All right, so let's go to share screen. And we are going to now talk about Donald Murray v. Umar Johnson, right? So Don, the guy who used to work at FDMG. Now, where can you find his case? His case is a state case. It's not a federally filed case. So you would go to courtconnect.courts.delaware.gov. I want to show you the screenshot first because some of his personal information is in the docket and I don't want to share that, okay? So this is where you can find the case yourself if you want. courtconnect.courts.delaware.gov. You'll see your case ID. You'll see it's Donald Murray v. Umar Johnson. You'll see that it was filed on Tuesday, April 6, 2021. You'll also see that it's a breach of contract case, okay? Now let's get into it with what has happened in this case. So starting from the bottom, you see that, actually, let's go up to April. I want to be very careful. Okay, here we go. April 6, 2021, you see the breach of contract claim was filed, right? It's a summons and a complaint that was filed on this date. Then you also see that term again, right? Request for informa par pares. Remember what I told you? That's when a plaintiff is requesting to have his filing fees, his or her, I should say, filing fees waived because he cannot afford the fees. So Judge Damberg is reviewing that request as of April 6th. And then you see April 8th, Judge Damberg approved the request. And now all fees and costs are waived. So Donald Murray does not have to pay any court fees as he's going through this lawsuit against Umar Johnson. You then see April 22nd, service by the sheriff is requested. You then see civil summons issued to Newcastle County Sheriff requesting that service be effected upon whom? Defendant Umar Johnson. You then see April 22nd, the summons was signed and sealed by the clerk, right? And you now see May 7th, 2021, service returned. So what does that mean? Well, let's see. Summons returned on April 26, 2021 as to Umar Johnson. The given/provided address is a high school, or rather is Moyer Academy High School. It looks like MA High School. Buildings are boarded over, windows and doors, and appears to be vacant. Internet search says property foreclosed and also indicated, don't believe the hype about subject buying the property. No matching DMV record for subject. So what does that mean, everyone? Well, allow me to tell you what that means. That means the sheriff went to FDMG, which they know as Moyer Academy, right, to try to serve Umar Johnson this lawsuit. However, when the sheriff arrived, they saw, as they described, a building that appears to be totally vacant and vacated. And when they did their internet search, because they have to do due diligence in trying to serve someone, right? They saw things on the internet that suggested that Umar Johnson perhaps doesn't actually own this property. Interesting. So thus far, it looks like they actually have not been able to serve Umar Johnson yet, right? Now, remember, once you get the sheriff involved, you as the plaintiff, you are doing your part in regards to service. So Donald Murray is not in question here. He has done his part. He's gotten the sheriff involved. And if the sheriff does their due diligence and they cannot find Umar Johnson, Donald Murray will be allowed to proceed because this is not his fault, right? Okay, so let's see if we have any questions here. I'm looking in the chat very quickly. Someone mentioned there is no board of directors. I believe that to be true. I haven't been able to find any information about a board of directors for FDMG. All right, so now we're going to talk about Don's case. So as you can see, this Delaware website, this county, they don't have a fully electronic filing process. So you can't actually see the complaint here. But we're going to discuss a breach of contract claim, right? Because you know, our tagline here is life lessons through a legal lens. So let's have a conversation about what Don needs. Let me stop calling him Don like I know him. Let's have a conversation about what Donald Murray needs to prove to be successful against Umar Johnson, shall we? So I created a little doc for us. Here we go. Proving breach of contract. Let's make this full screen. All right. To successfully bring a breach of contract claim, a plaintiff must first prove that a contract exists. So everyone, Donald Murray has to actually prove that he had a contract with Umar Johnson. This is why I'm always stressing on my channel, have written contracts, these handshake contracts, these verbal contracts. You can try to prove that they exist in court, but it is never going to be as effective as a written contract, okay? Someone said in the chat, you are a general liability lawyer, not criminal. I have done both, by the way, Be More Legends. I currently practice civil litigation, but I am a former prosecutor. So I've done both. Alrighty, so here is how you prove that you have a contract. First, offer. One party must make an offer and request that something be given in return. So for example, Donald Murray has to say to Umar Johnson, I will paint the walls of FDMG for $50. That's just an example, okay? Then you have acceptance. So now the other party must agree to the offer and voluntarily enter the contract. So now Umar Johnson has to say, why, yes, Donald Murray, you can paint FDMG for $50. And then lastly, you need consideration. So consideration is the legal term for the benefit that each party receives. Each party has to get some type of benefit from the contract. So in our example, you have Umar Johnson getting the walls painted at FDMG, and then you have Donald Murray getting the $50 in return, okay? So that's the first thing. Donald Murray first has to prove that he actually had a contract with Umar Johnson. Not that he wanted to have one, not that he thought that Mr. Johnson would pay him, but that they actually had a contract. Now, you see I have a little note here. Make sure you do your research because there are specific rules within each state, and the amount of detail in your contract is going to determine whether or not it actually helps you to prevail in court, right? So now, second, here we are. Prove that you fulfilled your contractual obligations. So now Donald Murray has to prove that he painted the walls of FDMG as he said he would, okay? Contract fulfillment follows the rule of substantial performance. That's another legal term, everyone. Substantial performance means that if the other party received substantially what was asked for, excuse my little typo here, the other is required to pay, right? So what does that mean practically? Here's what it means practically. Let's say there were a total of 10 walls that Donald Murray was supposed to paint, and he only painted 8 of those walls because he heard Umar Johnson on the phone telling someone, well, I'm not going to pay him, right? Donald Murray can still bring Umar Johnson to court because he can say, I acted in good faith. I fulfilled my contractual obligation because I substantially performed, because 8 out of 10 is enough for a substantial performance. Okay? And now, number 3, you have to prove that the other party failed to fulfill their contractual obligations. So Donald Murray has to prove that Umar Johnson never paid him, right? And here you see I have my little blurb, right? If payment was not remitted, the plaintiff has to prove the payment was never received. How do you do that? Well, such proof can include communications between plaintiff and the other party requesting. Listen, Pages thinks it's smarter than me, and it's not. It's correcting me wrong. Such proof could include communications between plaintiff and the other party requesting that they be sent payment, i.e., an invoice or something of that nature, right? So let's say Donald can show even text messages, right? Text messages, emails, any kind of communication between him and Umar Johnson in which he's saying, hey, you haven't paid me. Remember, you agreed to the $50. And then he receives some sort of communication confirming that that payment wasn't received. That is enough to substantiate that Umar Johnson did not fulfill his contractual obligation. One moment, water break. Okay. And now the last thing. Prove that the other party's failure caused plaintiff to incur damages. So this one is kind of self-explanatory, right? But actually in the legal world, it is a real tenet of a lawsuit, right? You can't just say you breached a contract and leave it at that. You have to say what you were deprived of, what you lost when this person breached the contract. So now my little blurb. Plaintiff must detail what she or he suffered as a result of the other party's non-fulfillment. So in this instance, right, Donald Murray could argue that the $50 in expected payment was not received despite the time and labor that he extended for the work. That would be enough to establish damages, right? So Donald Murray would say to the court, Your Honor, I have incurred damages because I took time that I could have been working on another job. I used labor that is physically arduous to fulfill my part of this contract, and Umar Johnson didn't fulfill his part. Okay? So that is the full breakdown of Donald Murray v. Umar Johnson. We're going to stop screen sharing now. All right, I'm back to full screen. I'm going to check out the chat. Let's see what's going on. Does an audible or video recorded agreement with or without consent count as a contract? Awesome question, Crime Spotter. You've been really on point with these very good questions. It depends on your state. So if you are in a state in which you are not allowed to record a conversation or to record an interaction without that person's consent, then it will not be of use to you in court. It will be inadmissible in court because it's not a legal communication. But if you're in a one-party state, right, where you can record someone, you can record an interaction, then absolutely. If Donald Murray has a video of Umar Johnson agreeing to pay him for work, but remember, specificity. Don't forget that, Crime Spotter. So he needs for Umar Johnson to say in this video how much money he's going to pay him, exactly what work he's expecting Donald Murray to complete, right? He would need some specifics in this video for it to really be of use to him. Crime Spotter then says, what if in the text message example, Umar said, I don't know what you're talking about. What then? Then you have a problem. Right? Because then you don't have, so if in fact there is a text message between Donald Murray and Umar Johnson, where Donald Murray says to Umar Johnson, hey, remember you owed me the $50 for painting FDMG? And Umar Johnson says in response, I don't know what you're talking about. Donald Murray has a problem, you guys. He does not have a written contract, and now he does not have Umar Johnson admitting that they ever had a contract. That's a problem. Let's see. Crime Spotter then asked, basically, if Donald's got no proof that Umar confirms nor hints at an agreement, is he dead in the water? Yes. Yes. The first step in proving that someone breached a contract that you had with them is proving that you had a contract. If Donald Murray cannot substantiate that he and Umar Johnson had a contract, he is dead in the water, Crime Spotter. He has no chance. Yes. So I'm going to take another sip of water. I've been doing quite a bit of talking. Please subscribe if you're not yet subscribed to my channel. I would greatly appreciate that. And let's see if there are any other questions. I see K Business is making a statement that Donald does not have a written contract. Well, if he doesn't have any communications between him and Umar Johnson, you guys, he's in for a rough time. He may not be able to recoup anything that he's owed, you know? So I've given you guys the breakdown of the two most recent Umar Johnson lawsuits, right? There are tons of them out there, but some of them are older, and these were the most recent ones that I felt we could have a conversation about the legal implications of these lawsuits, okay? I'm not going to stay on much longer unless there are specific questions. I'd like for someone who maybe couldn't have made the live to be able to jump in, right? So we're going to have one more round for questions. And other than that, we're going to call it a night. So we're going to give it, let's say, 10 seconds for questions. Here goes a question. Let's say Umar is a potential client. Would you have him stop giving dates, etc., about the school? Absolutely. I cannot even say that loud enough. Absolutely. If Umar Johnson was my client, one of the first things I would tell him to stop doing is to stop giving dates that the school, that FDMG is supposed to open. I would also tell him to stop announcing events that are going to happen at FDMG, because no one's sure when FDMG will actually exist, right? So he is in a way making statements that, like I said, he could still wiggle out of, right? Because he tends to say it's tentative. But if he were my client, I would recommend that he stops doing that. Hello Mello now says, what about communication on YouTube via people who are close to Umar who talk on his behalf? For the Don situation, no. So hello Mello, I love your question because we can have a quick conversation about hearsay. So for those of you who are unfamiliar with the term hearsay is when, it's literally what it sounds like. It is when someone else has said something that was overheard, and now that statement is trying to be used in court for the truth of the matter. So for example, let's say Hello Mello spoke to Umar Johnson's best friend on IG in the DMs. And Umar Johnson's bestie says, yeah, Umar told me that he told Don he was going to pay him. And then Umar told me that he maybe wasn't going to, or something of that nature, right? That's hearsay. That's not going to be admissible in court. Now, there are hearsay exceptions, right? However, those exceptions are very, very strict, and they have to be adhered to very, very strictly, right? And also, those exceptions are really something that only an attorney or a law student is going to be familiar with. I don't picture Donald Murray being able to effectively make hearsay arguments, because that's next level, right? But if in fact he is able to find some statements from some other people who are close to Umar, there is an exception he might be able to use. It's called an admission. So there is a hearsay exception. It's called admission. Some people call it admission by a party opponent. Some people call it an admission by opponent, and some just say admission. So in other words, the hearsay exception says that certain statements by your opponent or by your opposing party can be used, even if it's technically hearsay, because they're admitting to something they did that's relevant to the case. Again, though, the other party is going to argue against you. They're going to argue that it's still hearsay, that it shouldn't be allowed in. And you would have to be comfortable enough with the rules of procedure and evidence in that jurisdiction, because remember, this isn't a federal case, right? So you have to be comfortable enough with Delaware rules of evidence for you to argue hearsay exceptions. And that's next level. That's attorney level. And Donald Murray does not have an attorney that we've seen in this case. Crime Spotter says, can you serve a client with a gag order for their own good and they remain a client? Interesting. So it's not the norm for an attorney to serve a gag order on their own client. And I don't think I've ever heard of that happening. Now, what attorneys can do, what we can do is we can say to our client, hey, please don't speak about that. Please stop speaking about that. It's not in your best interest. If they ask you about it, tell them that you are invoking your Fifth Amendment right against self-incrimination and you're not going to speak. But the client can still choose to speak, right? You're welcome, Hello Mello. Hello Mello says, thank you for answering her question. Of course. We're at 5:50. I planned on being on for an hour. So you guys still have a few more time. I'll do the regular 10 seconds again, see if another question pops up. And if so, we'll keep it rolling. If not, we'll head on out. In the meantime, I want to say that I am always open to topic suggestions. I'm going to put in the chat here my email address. It's phyliciadcpearson@gmail.com. I'm not one of those people that has some sort of fancy or cool name that I use online, right? phyliciadcpearson@gmail.com. I'm checking for accuracy. I just use my name. I'm just me. So I am Phylicia D.C. Pearson. You're welcome to email me any legal topics that you spot out there that you think are interesting, that you think, I'd like to hear Phylicia talk about that. Hi, Can't Hide. You're absolutely welcome. I love talking about, like I said, I'm a law nerd, right? So I love talking about legal issues. And it's always so interesting when legal issues and pop culture meet, right? So my email is in the box. Please subscribe if you're not. And email me any topics you'd like me to address. I think where I may go next is the TI and Tiny criminal investigation. I really think it'll be an interesting chance to talk about interstate commerce and how that affects when you're crossing state lines and committing crimes, right? Interstate criminal investigations, human trafficking, sex trafficking, and all of those things. So, all right. As we're rounding out, Crime Spotter wants to know if there's any good Law 101 books that I recommend or videos. There's so much material out there. I wouldn't particularly recommend any of it, and here's the reason. Law is gray. Some people would have you believe that law is black and white, and it's not. It's gray. Almost anything is up for interpretation, and almost everything is susceptible to effective argumentation. I did just make that up off the dome, you guys. So there isn't any that I would recommend, because really a good attorney can wiggle their way out of almost anything. And that's the truth be told. So a lot of law books that you see, they interpret the law in a very black and white way, but that is just not how the law works. It's so fluid, it's so dynamic, and it's changing. It's constantly evolving, constantly changing. So no, there aren't any books I would recommend, but if there's a particular topic you'd like to hear about, feel free to send me an email and I will definitely cover it. And Crime Spotter does want to know my take on TI and Tiny. We'll save that for the next live. I'll be live again next Sunday at 5, and that's what we will do next Sunday. We'll do TI and Tiny and their criminal investigation. Before I head out, though, I have to talk to Can't Hide. Can't Hide said it changes to fit a narrative, it seems, when she talks about the law. Can't Hide. I'm not going to deny that that does sometimes happen, but here's what I will say. The law changes based upon the effectiveness of the person using it. That's really what it is. So if you get an effective attorney, yes, they can bend a narrative and shape a narrative. That's part of what effective attorneys do. I once read in a book a long time ago, I unfortunately can't remember what book, but the book said that the power of being an attorney, the power of being a lawyer, right, is that you can create your own reality, create your own version of events, and then argue that version of events so persuasively that you get other people to believe it. That's the power of being a lawyer, guys. Oh, and by the way, usually the only difference between lawyer and attorney is who's passed the bar, right? So I have passed the bar. I am an attorney at law in the state of New York, but I'm also a lawyer. Why? Because I went to law school and I have a JD. So I'm both. All righty. 554 would like me to talk on SDNY v. Trump, Crime Spotter says. Okay, I'll make note of that. Actually, I'm going to write it down now. Didn't I have a pen here? I guess I didn't. I'll write it down here. Alrighty, so it was nice meeting all of you, some of the newer people in the chat. I've had a great time chatting with you. We're about 5 minutes short, but we're going to head on out so that other people who weren't able to make it can jump in and watch this. And, feel free to like this video, share this video with anyone you think it might be useful for. If you know someone who is considering donating to FDMG, or if you know someone who has donated to FDMG, share this video with them. It may be of use to them for them to know some of the legal issues that Umar Johnson has going on so they can be abreast of what their options are. Okay. All righty, everyone. I am out. I'll see you later. See you next time on Empowered Esquire TV.